Hello and welcome to Judici's YouTube channel. Recently, you must have seen the news relating to tiff between center and judiciary regarding Collegium system, or rather we call it as appointment of Supreme Court judges. Therefore, in this video, we'll try to understand that what is Collegium system and why it is being criticized. For UGC NET exam also this topic is important. Hence, stay connected with this video. Firstly, let us understand that what are the constitutional provisions relating to the appointment of judges in Supreme Court and High Court. So according to Article 124 Clause 2, the Supreme Court judge is appointed by the President after the consultation with such number of judges of the Supreme Court and of the High Courts in the state. On the contrary, according to Article 217, the High Court judge is appointed by the President after the consultation with the CJI, the governor of the state, and so on is the language of Article 217. Right. So in both these articles, you must have observed that I have highlighted the term consultation. Now, how this term is going to be interpreted in three judges' case, we'll see it in the next slide. But what is the matter of debate over here? Right? Why there is a debate? So in 1973, there was this appointment of Justice A.N. Ray as the CJI over three more senior judges of the Supreme Court. And his appointment has basically challenged the judiciary independence. Now, this was the point when the struggle between the executive and the judiciary was triggered. After this event, in year 1981, a circular was issued directing executive interference in appointment and transfer of judges. Now, the constitutional validity of this circular was challenged by the series of petitions, and the case is popularly known as First Judges Case. Now, let us see that what was held in First Judges Case. So, in First Judges Case, the seven-judge bench held that the term consultation couldn't be interpreted to mean concurrence. So, as you can see that under Article 124 and 217, the term consultation has been given. So it couldn't be interpreted to mean concurrence. And accordingly, the ultimate power would be with the union government and not with the CJI in appointing or transferring the judges. So this was the observation made by the seven-judge bench in the case of First Judges Case. Right? In short, the primacy was given to the executive in the case of First Judges Case. Now, in year 1993, again appointment of Supreme Court judges came into question in the case of Supreme Court Advocates on Record Association versus Union of India, popularly known as Second Judges Case. So, in this very case, the 9-judge bench held that in case of conflict between the President and CJI with regard to the appointment of judges, the opinion of CJI will prevail. So, as we have seen under the First Judges Case, the opinion, the primacy was given to the executive. But in case of Second Judges Case, the primacy was given to the judiciary. Right? So, this is how the Second Judges Case has overruled the First Judges Case. Now, additionally, it also held that the powers of the CJI would be moderated by the Collegium system, which is only after ascertaining the opinion of two of the most senior judges of the Supreme Court. So this is how Second Judges Case has given birth to the Collegium system in India. Then finally in year 1998, the presidential reference to the Supreme Court was issued questioning the meaning of the word consultation in Articles 124, 217 and 222. So 222 article is basically related to the transferring of judges. So in which the bench of the Supreme Court reaffirmed the Second Judges Case and expanded the Collegium to include the CJI and the 4 more senior judges of the court after the CJI. Right. So these are the 3 important cases which is relating or which is given with respect to the Collegium system in India. Hence, Collegium system in the simplest sense means the system of appointment and transferring the judges that has evolved through the judgments of the Supreme Court. So neither in the Constitution nor there is a particular or a specific act which describes or which talks about the Collegium system. right? Now, what is the composition of the Collegium system? If we talk about the Supreme Court Collegium, it is headed by the CJI and it comprises four other senior most judges of the court as it was decided under third judge's case. Now, what are the issues with respect to the current Collegium system? So, as we have seen in the previous slide, that the second judge's case has established the primacy of the judiciary over the executive. Now, this system has basically disturbed the principle of check and balances. Also, this system lacks transparency and accountability. So, to address the issue of collegium, 99th Amendment was done, giving effect to the NJAC Act 2014. NJAC means National Judicial Commission Act, and according to which NJAC must comprise of CJI, two senior most judges of the Supreme Court, Law Minister of India, and two eminent members that are chosen by the selection committee. But within days of the 99th Constitution Amendment and NJC Act 2014 coming into force, the constitutional validity of both the amendment and the NJC Act was challenged. So in year 2015, the constitutional validity of 99th Amendment and NJC Act was challenged in the case of Supreme Court Advocates on Record Association versus Union of India. Popularly, it is known as Fourth Judge's Case. So in this very case, the bench, after looking into the composition of NJAC, they held that the involvement of executive in the appointment of judges, they have the tendency to infringe the independence of judiciary and separation of power. And this is how the NJC Act and the 99th Amendment, they were held to be unconstitutional and void. So we can also quickly see that how the appointment of judges takes place in different countries. So I've taken the example of three countries basically, US, UK and Denmark. So in case of US, the judges of the federal courts are appointed by the President of US with the advice of consent of Senate. Whereas in case of UK, there is this independent commission known as Judicial Appointment Commission, which looks after the process of selection of candidates for judicial office in courts and tribunals. Now, lastly, if I talk about the Denmark. So, Denmark is a country which has topped the World Justice Project Rule of Law Index in year 2021. So, in this country also, the judges are appointed by the Queen on the recommendation of Minister of Justice as advised by the Judicial Appointment Council. So, this is how the judges are appointed in other countries. Thank you for watching this video. Do like and share this video with your friends, and do not forget to subscribe Judges Academy to get the further updates.